If we can have your attention, I ask everyone to silence your phones who are visiting with us today.
Okay.
Welcome all of you to the Alabama Medical Cannabis Commission meeting today on October the 26th, 2023. As you noticed today, we started an hour later, but our meeting should be somewhat short today. Before we move any further, I'm going to ask Mr. James Harwell to have an invocation for us. James.
Father God, we thank you for the opportunity to come together today to carry on the business of the medical cannabis group. And Father, we pray for your wisdom, for your direction as we meet. And Father, most of all, we thank you for your love for us. And Father, how you bless us tremendously. We just pray in Jesus' name. Amen.
Thank you, Mr. Harwell. Before we go any further, I'll ask Mr. John McMillan, our director, to have a roll call of our commission members.
Mr. Vaughn.
Here.
Dr. Salisky.
Here.
Dr. Blakemore.
Present.
Mr. Gamble.
Here.
Dr. Martin.
Here.
Dr. Jensen.
Here.
Ms. Skelton.
Here.
Judge Price.
Here.
Ms. Hatchett. Mr. Harwell.
Here.
Dr. Safarsky.
Present.
Mr. Robinson.
Present.
Quorum, Mr. President.
Thank you, John. We do have a quorum present. All of you commission members should have received your minutes from Mrs. Peters last week from the October 12th, 2023 Cannabis Commission meeting. Is there a motion? If you've had a chance to review those minutes, is there a motion to approve the minutes?
So moved.
Got a motion from Mr. Harwell. Is there a second?
Second.
Got a second from Dr. Blakemore. All in favor of approval of the minutes, say aye.
Aye.
Any opposed?
Aye.
Thank you. Before we go any further, I'm going to recognize Mr. Mark Wilkerson to have a few comments about our motions that we will discuss today. Y'all have met Mr. Wilkerson in the past. He's part of our legal counsel. He's going to give a brief explanation today on the court proceedings since our last commission meeting and to explain what the actions the commission is permitted to take under the current TRO. So, Mark.
Commissioners, thank you. This will be brief. The court's continuing to entertain complaints and pleadings submitted by various interest holders in this process. It has a hearing set for the 30th of this month on we believe, a preliminary injunction request that is pending that regarding some of the issues that you're aware, some of the challenges overall, pre-existing challenges to the process. You're familiar with the court's prior decision in respect to the Verano application and the ability of this commission to rescind its orders in general, which was issued in June. Most recently yesterday, and this was actually indicated to the group by the court, and the court asked for proposed orders on this issue, the parties to get together and collaborate on proposed orders. Yesterday, the court entered an order modifying its temporary restraining order that it had previously issued that would have blocked further commission action in effectuation of any licenses and clarified that that order is modified in such a way as to permit today at this meeting the commission's consideration of the lifting of the administrative stay that had been applied as to all license awards and to rescind all the license decisions, that is both the awards and denials previously issued by this commission. So those are, they're listed separately as a stay and the rescission of the prior decisions, but they are essentially one action in that what the court allows this commission to consider and do today. So you're permitted to do that. That is on your agenda for the appropriate motion and vote, Mr. Chairman. Any questions?
Anyone on the commission have a question for Mr. Wilkerson? Any of our members on virtual, do you have any questions for Mark? Thank you, Mark. Appreciate that. Appreciate all the work of our outside legal counsel. They've been tremendous in helping us get to this point. So the first decision item, as Mark kind of alluded to, will be to consider lifting the administrative stay that was imposed on August the 31st, and that was considering the August 10th awarding of license. So our stay that was imposed August the 31st, this is the first item we will discuss. The first decision item is to consider lifting the administrative stay imposed by the Commission on August 31st, 2023. Is there a motion to lift the administrative stay? Got a motion from Judge Price. Is there a second?
Second.
Got a second from Mr. Gamble. Any other discussion on lifting that stay? I'm going to ask Mr. John McMillan for a roll call vote, and that way we can be accurate on our voting. Mr. John?
Mr. Vaughn,
Yes.
Dr. Saliski,
Yes.
Dr. Blakemore,
Yes.
Mr. Gamble,
Yes.
Dr. Martin,
Yes.
Dr. Jensen,
Yes.
Ms. Skelton,
Yes.
Judge Price, Ms. Hatchett, Mr. Harwell,
Yes.
Dr. Saflarsky.
Yes.
Pass, Mr. Chairman.
Thank you, Mr. McMillan. Motion passes. Now for the second item to discuss will be to consider rescinding the licensing decisions made on August the 10th of 2023. Seems like a lifetime ago we were talking about all these, but here we are, August the 10th. That was a long day over in the RSA boardroom, but this item is to consider rescinding the license awards and denial decisions made by the Commission on August the 10th. For clarification, we're considering rescinding all license awards and denials in all license categories. This action, if approved by the Commission, would mean that all 90 applicants are subject to an award of license by the Commission and able to avail themselves of the new procedures adopted by the Commission. Do I have a motion to rescind all license awards and denial decisions of August the 10th? Got a motion from Judge Price. Is there a second?
Second.
Got a second from Mr. Harwell. Any other discussion or questions from Commission members on this motion to rescind the license decisions made on August 10th? I'll ask Mr. John McMillan for another roll call vote on this motion.
Mr. Vaughn,
Yes.
Dr. Saliski,
Yes.
Dr. Blakemore,
Yes.
Mr. Gamble,
Yes.
Dr. Martin,
Yes.
Dr. Jensen,
Yes.
Ms. Skelton,
Yes.
Judge Price, Ms. Hatchett, Mr. Harwell,
Yes.
Dr. Saflarsky.
Yes.
Pass, Mr. Chairman.
Motion passes. Thank you, John. A couple of old business or new business items I'll make mention of today. The administrative timeline for the Rule 538-X-3-.20, the emergency rule, which is special procedures relating to certain applications. We discussed this at the last commission meeting. A couple of notes on this timeline will be a timeline has been developed based on the new procedures adopted by the commission and our actions today. Also, a copy of the timeline will be included in your materials in the future. Timeline is aggressive and will be demanding of our time. As I mentioned also at the last meeting, it is aggressive and certainly timely, we're hoping. We will review the timeline and plan to participate in the scheduled presentations in person or by Zoom. Recordings will be made available for each applicant. The timeline will be posted to the AMCC website. Later this afternoon, Ms. Peters will attend to that. The staff will be communicating directly with our applicants soon thereafter to schedule your appropriated time to make that presentation. Do any commission members have any questions on the timeline that we're proposing? Any of you commission members on virtual have any questions or concerns? If not, I have a prepared statement regarding my thoughts about the process that the commission adopted at its last meeting. The commission at its meeting on October 12th adopted a process by which applicants have the opportunity to make written and oral presentations to the commission in support of their application. In addition, applicants are allowed through a specific procedure and in a public presentation to address the commission regarding concerns they may have with the evaluation of their application. This process will be fair and effective for all applicants, only to the extent that there are no efforts to subvert it, especially when those efforts are meant to generate misinformation. The Commission's rules are clear that the Commission has full discretion as to license award decisions. Rule 538-X-3-.12 states that in part, the Commission remains the primary decision maker with regard to licensing and has authority to act independently of any third-party evaluation and recommendation. This means that the Commission has discretion to act consistently with such evaluation and recommendations to differently weigh the factors contained within such evaluation and recommendations, or to apply different factors and issue licenses based on reasons not considered by the third party, but upon such other factors as the Commission, in its discretion, may deem appropriate. This was reaffirmed in the rules adopted by the Commission at its last meeting. Rule 538-X-3-.20, 5C states, as provided in the Alabama Administrative Code, the Commission remains the primary decision maker with regard to licensing, and each commissioner retains full discretion to act independently of the previously generated third-party scoring and evaluations in applying the statutory and regulatory criteria. To reiterate and to avoid any confusion, each Commission member has independent discretion when evaluating the suitability of all 90 applicants. The law provides for the appointment of commissioners who have the full weight of that discretion. I am confident in the qualifications and the ability of each commissioner in executing the mandates of that law. Regarding inspections, Alabama Code 20-2A-53 does not require the Commission to inspect applicants' facilities prior to an award of a license. Alabama Code 20-2A-53, Subject A4, provides that inspections are to be conducted at each facility of an applicant prior to being issued a license, as well as ongoing on-site inspections of the facilities of a licensee. The difference being, always keep in mind that there is a difference to where the Commission operates between the award of a license compared to the issuing of a license. There is a distinguished difference there, so don't get lost on that. Our rules clearly distinguish between the award of a license and the issuance of a license. As I mentioned at the outset of this statement, these are my thoughts. Are there any other Commission members here today in person who have thoughts or comments that they would like to share? If so, you now have the floor. Ms. Skelton.
I'm sorry. I do have a question on this timeline. I apologize, but I'm just seeing it for the first time. On November 9th, it says deadline for AMCC to make general scoring information available to all applicants. So, is that everyone's score will be available to everyone?
I believe that's going to be, Justin, would you want to address this? I believe that's accurate, Lori.
I want to make sure I understand your question.
Okay.
All right, so.
The deadline on November 9th, when it says deadline for AMCC to make general scoring information available to all applicants, does that mean that general scoring will be available to all applicants, not just their own specific scoring, but general scoring as to everyone's score?
In the emergency rule, I'll reference the rules.
Okay.
I think probably the timeline was shorthand for what the rule says in detail. So under paragraph 5 of the emergency rule adopted by the Commission at the last meeting, it says, regarding third-party scoring data and tabulations previously generated for applications, A, within 10 days of the effective date of the rule as amended, the Commission will make available to all applicants. That's 10 days from when the applications become subject to award. Number 1, general scoring criteria utilized by the third-party scorers, along with information in the Commission's possession regarding each scorer's training and qualifications applications, excluding personal identifying information. Number 2, notice of any instance where the same score was not used in scoring the same sections of applications within a license category. And then it says, in addition to the general disclosures in subparagraph A, those 2 I just mentioned, which go to everyone, okay? The commission will, upon request, provide an applicant with the opportunity to inspect the scoring sheets and any specific score notes for such applicant in the commission's possession, subject to the redaction of personal identifying information. And then the last thing I would mention to you that I think gets subsumed in your question is there's also a deadline within 15 days of today when parties that have submitted redacted applications for public viewing with redactions that go beyond what is specified in the rule, for them to resubmit a unredacted copy with those areas unredacted. And if that doesn't satisfy the commission staff, they have the right to make further unredactions. So that will be published as well. Have I answered your question?
Yes, as it relates to the November 9th, but I have another question.
Okay.
Since you're up there, yeah.
Okay.
The November 26th, deadline for applicants to submit written requests for applicant-specific scoring information. So that's the deadline for an applicant to submit the request. And again, I apologize, I wasn't able to be here last month, and I just got this in front of me. If it's in here, I apologize. Maybe you can direct me. Is there a deadline in which the staff has to respond to that written request of the applicants?
No, there's not a specific deadline, although it is anticipated that information will be made available in time for the presentations and the submission of the briefs. They have an opportunity to file up to a 20-page brief. They can do documentary information associated with the presentation. The goal is obviously for all this information to be in hand so the applicants can make a knowing presentation based on all the information provided. The reason there's not a specific timeline is that we're not 100% sure how much effort will have to be made to do the redactions that are specified in this with the score notes, for example. We just don't know yet, and in the speed, I don't think we've had an opportunity to do that. But the staff is committed, I'm told, to do that as quickly as practicable. Is that correct, Justin?
Correct.
It's been a problem getting information. I just want to make sure that we're fair to the applicants, that the information they request gets to them in plenty of time to be able to make their presentation.
Okay. May I leave the podium?
Yes, sir. Thank you.
Any other questions for Mr. Wilkerson from any other commission members? Any of you on virtual have a question or concern? Ms. Gelton will make sure that all information is shared expediently as much as possible. The presentations that will be begin on November the 27th, they will probably combine a lot of video presentations, written presentations, whatever the applicant chooses to do. So I think that every platform will be available for every applicant to make the best possible presentation to the commission. So keep that in mind as we move forward. And like I said, Ms. Peters will be posting the tentative schedule later this afternoon, and that could change based on how many applicants take advantage of the presentation option. We don't really imagine that all 90 applicants may be willing to do this, but those that do will be afforded that time, and we'll move forward judiciously based on how many we have to schedule. So we have a aggressive timeline beginning November the 27th for a few days. Certainly we know we have fewer cultivators and laboratory testing applicants and secure transporters and processor applicants, a few less dispensaries, so they will take less time, but the integrator applicants will take much more time. So much more time has been allocated for that effort. So any questions from commission members before we get ready to adjourn? Our next meeting is November the 27th, and that will be a 10 a.m. meeting, and that will begin our timeline for hearing presentations. So commission members that are planning to come to Montgomery, we hope that several will be here. The goal is for every applicant to have their videoed and documented so that those commission members that are not able to be present that day or not watch it virtually can have access to it. So every opportunity will be provided to the commission member to see every applicant's presentation. We know it would be almost impossible to have all 12 commission members on site or even attending virtually at every day of this, because it's going to be several days. So every effort will be made to accommodate every commission member. Any questions before we ask for a motion to adjourn? November 27th at 10 a.m. right here in this State House room, number 200. Do I have a motion to adjourn?
So moved.
Got a motion from Mr. Harwell. Is there a second?
Second.
A second from Dr. Blakemore. All in favor of adjournment, say aye. Aye. We stand adjourned. Thank you. Well, that's fast. That's fast.